Let me give you some words that come out on your test, jury charges. 180, number 1, you have George L. Smiley, Jane Gregory, State of Colorado, Department of Institutions, and George Smiley. This is going to be test 1, 180 for 5 minutes, okay? Members of the jury, you are instructed that the information alleges the following charges against the defendant George L. Smiley to have been committed on July 13, 1986. Count 1, murder in the first degree against Jane Gregory. Count 2, murder in the first degree during the commission of a felony against Jane Gregory. Count 3, assault in the first degree against Jane Gregory. Count 4, first degree sexual assault against Jane Gregory. Count 5, second degree burglary against Jane Gregory. Count 6, robbery against Jane Gregory. Count 7, criminal attempt first degree murder against Jane Gregory. To each of these counts, the defendant has entered a plea of not guilty by reason of insanity at the time of the alleged commission of the offense. It is now your function to determine the issues raised by the defendant's pleas. You are instructed that the defendant's guilt or innocence as to an alleged offense is not in any way involved herein. You are further instructed that the sole purpose of the evidence admitted in this case is to enable you to justly determine by your verdicts the question of the sanity or insanity of the defendant, George L. Smiley, at the time of the commission of the alleged crimes on July 13, 1986, and that you should determine these issues wholly upon the evidence and the written instructions herein and now given by the court. There are 2 types of evidence from which a jury may properly find the truth as to the facts of a case. One is direct evidence, such as the testimony of an eyewitness. The other is indirect or circumstantial evidence, that is, the proof of facts or circumstances from which the existence or non-existence of other facts may reasonably be inferred. As a general rule, the law makes no distinction between direct and circumstantial evidence, but simply requires that the jury be satisfied of the defendant's sanity beyond a reasonable doubt from all of the evidence in the case. The statutes of the state of Colorado provide as follows. A person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or being able to so distinguish, has suffered such an impairment of mind by disease or defect as to destroy the willpower and render him incapable of choosing the right and refraining from doing the wrong, is not accountable. And this is so, howsoever such insanity may be manifested by irresistible impulse or otherwise. But care should be taken not to confuse such mental disease or defect with immoral mind, mental depravity, or passion growing out of anger, revenge, hatred, or other motives, and kindred evil conditions, for when the act is induced by any of these causes, the person is accountable to the law. This is an informational instruction and must have no persuasive bearing on the verdict you arrive at under the evidence. If a defendant is found not guilty by reason of insanity, it is the duty of the court to commit the defendant to the Department of Institutions until such time as the defendant is determined to no longer require hospitalization because he no longer suffers from a mental disease or defect which is likely to cause him to be dangerous to himself, to others, or to the community in the reasonably foreseeable future. It is the theory of the defense that George Smiley was so diseased or defective of mind at the time of the alleged offense as to render him legally insane. The Varied expert testimony presented conflicting evidence regarding current knowledge in the area of mental disease and defect. It is undisputed that George Smiley suffered from a mental disorder at the time of the alleged offense. It is your duty to decide if the prosecution has proven beyond a reasonable doubt that this mental disorder did not constitute legal insanity. The defense theory is that most psychiatrists do not pretend to know the genesis or origins of the disease called character disorder, and do not offer nor suggest any real treatment for it. On the other hand, scientific research in a variety of disciplines has found some answers to the question of causation of violence in persons who do not display symptoms of other classic mental illnesses. While not all of the medical establishment is prepared to accept the work in this area, it is the defense theory that where response to treatment by both chemical and physical electrical intervention has demonstrated results such as the evidence suggests that research should be given credence. And in view of the testimony of all witnesses, there must be some reasonable doubt. That's hard. And then you have 180, number 2. You have George L. Smiley. It continues, and Jane Gregory. Okay? And this is going to be 180, number 2, jury charge for 5 minutes, you all. Ladies and gentlemen, with respect to count 4 in the charges against George L. Smiley, that being second-degree burglary, if you are not satisfied beyond a reasonable doubt that the defendant is guilty of this offense, he may be found guilty of a lesser offense, if the evidence is sufficient to establish his guilt of such lesser offense beyond a reasonable doubt. The offense of second-degree burglary as charged in this case includes the lesser offense of first-degree criminal trespass. A person commits the crime of first-degree criminal trespass if he knowingly and unlawfully enters or remains in a dwelling of another. The elements of first-degree criminal trespass are 1, knowingly and unlawfully enters or remains, 2, in the dwelling of another. The jury will bear in mind the burden is always on the prosecution to prove beyond a reasonable doubt each and every material element of any lesser included offense. The law never imposes upon a defendant in a criminal case the burden of calling any witness or producing any evidence. If after considering all of the evidence you find that the prosecution has established beyond a reasonable doubt that the defendant committed the crime charged or the lesser included offense, you should so find the defendant guilty and should so state in your verdict. If you do not so find, you should find the defendant not guilty and should so state in your verdict. You are not in any event to find the defendant guilty of more than one of the following offenses: second-degree burglary of a dwelling, first-degree criminal trespass. Concerning the charge of second-degree burglary of a dwelling, certain words or phrases have a particular meaning. The following are the definitions of these words and phrases. 1. Dwelling means a building or room within a building, such as a hospital room which is used, intended to be used, or usually used by a person for habitation. 2. Unlawfully entering or remaining means entering or remaining in or upon premises when a person is not licensed, invited, or otherwise privileged to do so. Concerning the charge count 4, first-degree sexual assault by George Smiley against Jane Gregory, the definition of sexual assault is knowingly inflicting sexual contact on a victim without her consent. Concerning the charge of first-degree sexual assault in this case, certain words have a particular meaning. The following are the definitions of these words or phrases. A person acts knowingly with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such circumstance exists. A person acts knowingly with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. These charges will be considered by you after resolution of the defense of sanity. You will consider these charges if the people have proved beyond a reasonable doubt that George L. Smiley is aware of his actions and is to be held accountable under the law. Sexual contact means the intentional touching of the victim's intimate parts by the actor or of the actor's intimate parts by the victim, or the intentional touching of the clothing covering the immediate area of the victim's or actor's intimate parts if that sexual contact can reasonably be construed as being for the purposes of sexual arousal, gratification, or abuse. Any actor who knowingly subjects a victim to any sexual contact knowing that the victim does not consent commits sexual assault in the third degree. The elements of sexual assault in the third degree are therefore: 1, knowingly subjects a victim to sexual contact; 2, knowing the victim does not consent. To constitute a crime, there must be the joint operation of an act forbidden by law and a culpable mental state of the defendant. Culpable mental state in the case of second-degree burglary means knowingly and with specific intent, as those terms are explained in this instruction. Culpable mental state is just as much an element of the crime as is the act. The culpable mental state must be proven beyond a reasonable doubt as a matter of fact, either by direct or circumstantial evidence. This would be taken into consideration in your deliberations after a finding of sound mind upon finding that George L. Smiley was of sound mind at the time this crime was committed. The culpable mental state may be manifested by the circumstances connected with the perpetration of the offense and the sound mind and discretion of the defendant. Commission of the act alone does not warrant the presumption that the defendant had the requisite culpable mental state. A person acts knowingly with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of that nature or that the circumstance exists. Where a crime consists of an act combined with a specific intent, as does the crime of second-degree burglary, the requisite specific intent for that particular offense is the specific intent to commit the crime of sexual assault. In the case of sexual assault, the requisite mental state is knowingly inflicting sexual contact on a victim without her consent. The requisite specific intent for a particular offense may be manifested by the circumstances connected with the perpetration of the offense and the sound mind and discretion of the defendant. Proof of the commission of the act alone does not warrant the presumption that the defendant had the requisite specific intent for a particular offense. Specific intent is a state of mind voluntarily and willfully to do or perform an act which will affect a certain result. Such an act must not be the result of accident or proof of insanity or innocent reason. These instructions and definitions will apply in your deliberations only after the people have satisfied your, and we'll get ready for your 160s. So you have on your 160 test number 1, different book. And so it says no proper names. Okay, so let me check. Let me just make sure I don't see anything. I don't see anything, okay, you all? This is 160 number 1 jury charge for 5 minutes. Members of the jury, in this particular case, it is the duty of the plaintiff to prove every vital part of his claim by a preponderance of the evidence. This is also called the burden of proof or the burden of persuasion. A preponderance of the evidence simply means a sum of evidence which is enough to persuade you that the plaintiff's claim is more likely true than not true. In deciding if any fact has been proved by a preponderance of the evidence, you may view the testimony of all of the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of a claim or contention by a preponderance of the evidence, you should find against the party making that claim or contention. The plaintiff claims that the defendants were negligent and that their acts were a legal cause of damage sustained by the plaintiff. In order to prevail on this claim, the plaintiff must prove by a preponderance of the evidence, first, that the defendant was negligent, and second, that such negligence was a legal cause of damage sustained by the plaintiff. Negligence is the failure to use reasonable care. This care is that degree of care which a reasonably careful man would use under like events. Negligence may consist either in doing that which a reasonably careful person would not do under like events, or in failing to do that which a reasonably careful person would do under like events. Members of the jury, when knowledge of a technical subject matter might be helpful to the jury, a person having some training or experience in that technical field, one who is called an expert witness, is allowed to state his or her view of those technical matters. Merely because an expert witness has expressed an opinion, however, does not mean that you should accept that opinion. So just as with any other witness, it is up to you to decide whether to rely upon it. And when an expert witness has been or will be paid for reviewing and speaking concerning the facts, you may view the idea of bias then, where court testimony is given with regularity and is a large part of the witness's income. Negligence is a legal cause of damage if it directly and in natural and continuous sequence produces or adds greatly to causing such damage. So it can reasonably be said that except for the negligence, the loss, injury, or damage would not have occurred. Negligence may be a legal cause of damage even though it operates in combination with the act of another, some natural cause or some other cause where such other cause occurs at the same time as the negligence, and if the negligence contributes substantially to producing such damage. If the evidence proves negligence on the part of the defendant, which was a legal cause of damage to the plaintiff, you will then consider an issue, in this case arising from a defense asserted by the defendant and based upon what is called contributory negligence. You must then take into consideration if the plaintiff in any way contributed to causing the accident and perhaps was partially at fault. We will talk about this further in just a little while. Negligence is the failure to use reasonable care. Reasonable care is that degree of care which a reasonably careful person would use in like events. Now, negligence may consist in doing something that a reasonably careful person would not do under like events, or in failing to do something that a reasonably careful person would do under like events. The driver of a motor vehicle, when ordinarily careful, will be alerted consciously of the fact that he is in charge of a machine capable of projecting into serious results any negligence of his own. Thus, his caution must be adequate to that duty as related to all the surrounding events. A pedestrian, on the other hand, has only his own physical body to manage, and which is to set in motion a cause of injury. While usually that fact limits the capacity to cause injury as compared with a car driver, still, in using ordinary care, he too will be alertly conscious of the mechanical power acting on the public roadway and of the possible serious results from any conflict between himself and such forces. And the caution asked of him is measured by the danger or safety apparent to him in the conditions at hand, or that would be apparent to a person of ordinary prudence in the same position. Ladies and gentlemen, in just a little while you will retire to the, and then you have your 160 number 2, and it says no proper names. This will be 160, number 2, for 5 minutes. Jury charge. You have now been sworn as the jury to try this case. This is a civil case involving a disputed claim or claims between the parties. Those claims and other matters will be explained to you later. By your verdict, you will decide the disputed issues of fact. I will decide the questions of law that arise during the trial, and before you retire to deliberate at the close of the trial, I will instruct you on the law that you are to follow and apply in reaching your verdict. In other words, it is your responsibilities to determine the facts and to apply the law to those facts. Thus, the functions of the jury and the functions of the judge are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful for you to understand how a trial is conducted. In a few moments, the attorneys for the parties will have an opportunity to make opening statements in which they will explain to you the issues in the case and summarize the facts that they expect the evidence will show. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be received as evidence. After all the evidence has been received, the attorneys will again have an opportunity to address you and to make their final arguments. The statements that the attorneys now make and the arguments that they later make are not to be considered by you either as evidence in the case or as your instruction on the law. Nevertheless, these statements and arguments are intended to help you properly understand the issues, the evidence, and the applicable law, so you should give them your close attention. Following the final arguments by the attorneys, I will instruct you on the law. You should give careful attention to the testimony and other evidence as it is received and presented for your consideration, but you should not form or express any opinion about the case until you have received all the evidence and the arguments of the attorneys, the instructions on the law from me. In other words, you should not form or express any opinion about the case until you are retired to the jury room to consider your verdict, after having heard all of these matters. The case must be tried or heard by you only on the evidence presented during the trial in your presence and in the presence of the attorneys and myself. You must not conduct any investigation of your own. Accordingly, you must not visit any of the places described in the evidence or the scene of the occurrence that is the subject of the trial unless I direct you to view the scene. Also, you must avoid reading newspaper headlines and articles relating to this case and trial. You must also avoid seeing or hearing television and radio comments or accounts of this trial while it is in progress. The attorneys are trained in the rules of evidence and the trial procedure, and it is their duty to make all objections they feel are proper. When a lawyer makes an objection, I will either overrule an objection to a question, the witness will answer the question. When I sustain or uphold an objection, the witness cannot answer the question. If I sustain an objection, you must not speculate on what might have happened or what the witness might have said, had I permitted the witness to answer. You should not draw any inference from the question itself. During the trial, it may be necessary for me to confer with the attorneys out of your hearing, talking about matters of law and other matters that require consideration by me alone. It is impossible for me to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. During the trial, we will take recesses. During these recesses, you shall not discuss the case among yourselves or with anyone else, nor permit anyone to say anything to you or in your presence about the case. Further, you must not talk with the attorneys, the witnesses, or any of the parties about anything until your deliberations are finished. In this way, any appearance of something can be avoided. If during a recess you see one of the attorneys and he or she does not speak to you or even seem to pay attention to you, please understand that the attorney is not being. Okay, and that concludes your jury charge test, you all. The 160s were much better than the 180s, right, you all? Have a great day. We ordered a lot of new material. It should be here today, so I'm excited about that, okay? Give you all some fair stuff. Everything seems a little tough. Have a wonderful day, you all.